Ladies and gentlemen, welcome to the CIL eAcademy and this week's guest lecture by Justice Hanqin on 2 decades in retrospect, some reflections on third-party settlement at the World Court. This lecture is scheduled to last for approximately 60 minutes, a lecture followed by a Q&A. Please allow me to now hand over the floor to our moderator and co-director of the eAcademy, Professor Patricia Galvão-Teles.
Thank you so much, Zoe, and greetings to all. And first of all, let me warmly welcome Judge Xue, who has accepted our invitation to be with us today for this guest lecture on the module International Dispute Settlement. We are really honored to have you, Judge Xue. It's really a true pleasure, an honor and privilege to be able to count with you among our lecturers for this first CIL eAcademy. I would like to just say a few words of introduction, and I have to make a disclaimer that I will only give you some highlights of Judge Xue's curricula, because it would be too long to give a proper introduction, and because we are looking forward to hearing from you and also to have some time for our participants to ask you some questions, because it's really a privilege for them to have you in their living room, so to speak. I will just highlight some of the aspects of your your work and your professional background. So it's probably not news for our dear participants that we are honored to have a judge from the International Court of Justice. You've been a judge since 2010, and you are currently vice president of the ICJ. So it's again a true honor to have you. Also for Nilofer and myself, we are very proud to say that you are a former member of the International Law Commission, where you have served since 2001 until 2010. And you've been so far the first and only female that has chaired the commission back in 2010, and also one of the first women to have been elected to the International Law Commission, together with our dear friend and very much missed Paula Scaramaya. So it's really an honor that both a Chinese jurist and a Portuguese jurist were the first 2 female elected to the International Law Commission back in 2001. You have a very long governmental experience, having been Director General of the Department of Treaty and Law at the Ministry of Foreign Affairs, Ambassador of China to the Netherlands, the Permanent Representative of China to OPCW, also in The Hague, and Ambassador to ASEAN. As a prolific academic, you have taught both in China and abroad, including in the Hague Academy and in the Xiamen Academy. And Judge Xue is also author of numerous publications. I would highlight also that Judge Xue is currently a member and currently president of the Institut de Droit International, and a very prestigious association of the most distinguished jurists in international law. And last but not the least, I have also the privilege to let our participants know that Judge Xue is member of the CIL International Advisory Panel. So we couldn't be more honored to have you today. It's really a true delight, and for me personally, and for Nilofer to have you, it's a great honor. And I will pass you immediately the floor so that we can listen from you on the work of the International Court of Justice, some reflections on third-party settlement at the World Court. And then I'm sure our participants will have a couple of questions for you. So Judge Xue, the floor is all yours. Thank you very much.
Thank you, Patricia, for your very kind words to me. Nilofer, I am so happy now you're heading the center. Dear colleagues, it's a great privilege and honor for me to be invited to give this special lecture at the Center's eAcademy this year. At the outset, I wish to express my warm congratulations to the Center on its innovative and courageous responses to the challenges posed by the COVID-19 pandemic, among which is the establishment of this eAcademy. After the pandemic, the world will definitely change in many ways of our life and work. I'm glad that the center is taking the lead to direct changes for the betterment of the world. In today's lecture, I would like to share with you with some of my reflections on the work of the court in the past 2 decades. The 2 aspects in this lecture will be discussed. One is the features of recent cases. The court has increasing workload and greater variety of the cases. Second, jurisprudence relating to jurisdiction of the court and incidental proceedings. Next year will mark the 75th anniversary of the court. In its 75 years history, the court has received 150 contentious cases and 27 requests for advisory opinions, totaling 177 cases on its general list. Among these cases, 58 were initiated in the past 2 decades, making up almost 1/3 of the total number. In the past 6 to 7 years, the court received on average 4 new cases each year, whereas in the first 50 years of the court history, the average number was around 2 cases a year. Currently, there are 15 cases pending before the court. The same is true if you look at the number of judgments and advisory opinions rendered by the court. In its 75 years history, the court has altogether delivered 133 judgments and 28 advisory opinions. During the 1960s and the 1970s, because of the judgments in the Southwest Africa cases, the court's reputation suffered significantly. It failed to live up to the expectations of the international community in supporting decolonization movement. As a result, the caseload dropped drastically. It went through a domain period when there were hardly any case coming to the court. In 1971, at one point of time, the docket of the court was even bottom out. No more pending cases before it. This crisis situation gradually improved till the 1980s. By the time of its 50th anniversary in 1996, the court has turned on a new leaf with many more cases and a much larger clientele. Since then, the number of judgments and advisory opinions delivered by the court has greatly increased. The court publishes judgments, advisory opinions, and orders each year in the ICJ reports. As we can see from the bookshelves, the reports were very thin in the 1970s, whereas nowadays each year's report would consist of more than 1 volume, each containing hundreds of pages. Along with the growth of the court's caseload, the variety of cases has also increased. The types of cases submitted to court have greatly diversified. In the past, cases before the court mainly involve traditional subjects of international law, such as territorial disputes, nationality, maritime issues, international organizations, economic interests, etc. In the past 20 years, while those subjects continue to feature on the court's docket, More cases nowadays concern contemporary issues of international law, such as human rights, environmental protection, sovereign immunities, so on and so forth. Since 1999, the court has received 3 cases concerning alleged violations of the Genocide Convention and 3 cases relating to alleged racial discrimination. In the same period, the court has not only dealt with the 5 cases on international environmental law, but also rendered compensation for environmental damages for the first time in its history. A significant number of cases brought before the court has a high political profile, from a consular protection case concerning espionage allegations, regional armed conflicts, to sanction issues. The court has been pushed to the center stage of the world affairs to handle some highly sensitive cases. To give a few examples, the Jadhav case between India and Pakistan concerning consular protection, and Chako's advised opinion case, Ukraine versus the Russian Federation over allegations of terrorism financing and racial discrimination, diplomatic crisis in the Gulf region, the cases brought by Qatar versus United Arab Emirates, U.S. sanctions against Iran, that Iran filed 2 cases against United States. Of course, this does not mean that cases in the past had no political ramifications. Some of them equally arose from a broader political context. For instance, in the Tehran hostage crisis case between the United States and Iran, where the American diplomats and consular officers were taken hostage in Iran. Military and paramilitary activities in against Nicaragua case between the United States and Nicaragua, which involved US foreign policy in Central America. Lockerbie cases concerning terrorist bombing of civil airlines. In the Tehran hostage case, the court has already acknowledged that legal disputes between sovereign states by their very nature are likely to occur in political contexts and often form only one element in a wider and long-lasting political dispute between the states concerned. In the domestic context, people often discuss relations between law and politics and how judges should handle this relationship. In international adjudication, there is no such thing as a political question doctrine. We can say with certainty that this is an inherent feature of the cases before an international court that only deals with disputes between states. Cases before the ICJ are bound to be politically complicated, economically significant, or socially important, as the sovereign states are directly involved. These elements may vary from case to case, but only in terms of their degree. In recent years, more cases of a high political profile are submitted to the court. The tendency to come to the court for judicial settlement, however, is often accompanied with the advocacy of rule of law. With the effect of social media and other public coverage, the role of the court in international affairs has attracted much more attention from all parts of the world. So this is the feature I like to bring to your attention. The second feature of the court's work is that in the recent jurisprudence of the court, you may notice they're particularly related to the question of jurisdiction and incidental proceedings. In contentious cases, we know proceedings are instituted either through the notification of a special agreement by the parties or by the filing of a unilateral declaration. When the court receive receive a case on the basis of a special agreement, generally the question of jurisdiction is settled because both parties have consented to accept jurisdiction of the court. But if the case is filed unilaterally by one party to the dispute, the things would be quite different. Under the statute and the rules of the court, there is one special procedure called preliminary objection. Pursuant to Article 40 of the court's statute, contentious cases may be brought to the court either jointly by two parties as mentioned by a special agreement or by one party through the filing of an application. In the latter case, there is one of the parties to a dispute that institutes the proceedings in the court. For instance, we know in the Ukraine versus Russian Federation case, both states are party to the International Convention on the Elimination of All Forms of Racial Discrimination, the convention generally known as CIL acronym. Ukraine claimed that Russia had breached its international obligations under the convention and invoked Article 22 of the convention to file case against Russia in the court. We call this type of legal action unilateral institution. Following the submission of an application, if unilaterally instituted, the respondent state may raise objection to the jurisdiction of the court and admissibility of the application. Once the respondent state raises such objection, the main proceedings on the merits shall be suspended. Sometimes, when circumstances are so required, the court may also decide to examine the question of jurisdiction and admissibility first. In any event, the court has to determine first whether it has jurisdiction in the case. If the court decides that it does not have a jurisdiction or the application is not admissible, the case will stop there and be removed from the general list of the court. That's the end of it. If the court decides otherwise, finding that it has jurisdiction in the case, then it will proceed to deal with the merits. So this is a special jurisdictional phase. Usually, this phase does not exist in the domestic legal procedure. In the past 20 years, there had not been as many cases submitted to the court by special agreements of the parties as in the first 55 years of the court. Among 150 contentious cases on the court's docket, there were 18 cases submitted by special agreements, but only 4 of them were filed after 2000. Much more cases are now instituted by unilateral applications. In these cases, seldom has the respondent raised no objections to the jurisdiction of the court or admissibility of the application. Statistics published by the court indicate that since 1946, preliminary objections have been formally raised in 49 cases. 26 out of these preliminary objections, that's to say more than half of them, were raised after 2000. Especially in the past 10 years, in nearly half of the cases, preliminary objections were raised. That almost cover every possible occasion where preliminary objections could be raised. Why, you may wonder, why I have to talk so much about preliminary objections? As we know, the court, when a case is filed in the court, then we'll have to examine the jurisdiction first. Only when the court is sure it has sound basis for its jurisdiction, the case can proceed. So objection to the jurisdiction of the court may be on various grounds. For instance, personal jurisdiction, whether the court has a personal jurisdiction in the case, whether the court has a subject matter jurisdiction, or whether it has temporal jurisdiction or territorial jurisdiction. So I give you some example. Personal jurisdiction is the case where the court has to examine whether the party is qualified as a state to bring the case. You may say, well, seems in real life, this should not, not difficult question. But in practice, actually, we do have this kind of a case. For instance, cases against former Yugoslavia, the former Federal Republic of Yugoslavia, later called Serbia, Montenegro. And in several cases, the court, addressed the question of the international personality of the entity, whether Serbia, Montenegro was really qualified as a state member of the United Nations, whether it's a state party to the statute of the court. And then it has to decide whether it has access to the court and Article 35 of the statute. So this is the personal jurisdiction ground. And we also have in many cases to deal with the subject matter jurisdiction, whether the subject matter of the dispute concerns the provisions of the relevant convention. And this is a very important topic, and I'll come to that later with more discussions on that. And for temporal jurisdiction, oftentimes we have to examine the jurisdictional ground to determine whether the treaty concerned is still valid or still in force, or whether the treaty applied to events prior to the conclusion of the treaty. So this is another aspect of the jurisdictional ground. In recent cases, preliminary objections raised before the court focus more on the subject matter of a jurisdiction. This is especially true when the cases concern allegations of serious violations of international treaties, such as the Treaty Against Racial Discrimination, Torture Convention, Genocide Convention, or even bilateral treaties, for instance, cases between Iran and the United States that concerns interpretation and application of 1955 Treaty of Amity between the two countries. A more concrete example is the Ukraine versus Russian Federation case. One of Ukraine's claim was that number of actions taken by Russia in Crimea constitute racial discrimination under CIL. That's the Convention Against Racial Discrimination that against Ukrainian and Crimean Tatar population, such as imposing restrictions on education in Ukrainian and Crimean Tatar language. Russia, on the other hand, argued that the real issue in dispute between the parties did not concern racial discrimination, but the status of Crimea. It further contended that number of rights invoked by Ukraine were not protected under CIL, including the absolute right to be educated in one's native language. So in determining its subject matter jurisdiction under CIL, the court first identified the subject matter of the dispute. It found that the subject matter of the dispute, as far as CIL is concerned, was whether the Russian Federation breached its obligations under CIL through discriminatory measures allegedly taken against Crimean Tatar and the Ukraine communities in Crimea. The court then looked at the provisions of CIL, taking into account the broadly formulated rights and obligations contained in the convention. The court found that measures which Ukraine complained are capable of having an adverse effect on the enjoyment of certain rights protected by the convention. Therefore, the court held that claims of Ukraine fell within the provisions of CIL, and it had subject matter jurisdiction to entertain these claims. This case presents a typical example of the respondent's state challenging the subject matter jurisdiction of the court through preliminary objections. While this type of challenge become more frequent in recent years, the court has also developed a consistent methodology to determine its subject matter jurisdiction in a case. First, the court would identify the subject matter of the dispute between the parties on an objective basis. In a series of recent judgments on preliminary objections, the court has reiterated that it is for the court itself to determine on an objective basis the subject matter of the dispute between the parties by isolating the real issue in the case and identifying the object of the claim. In doing so, the court examines the application as well as the written and oral pleadings of the parties, while giving particular attention to the formulation of the dispute chosen by the applicant. It takes account of the facts that the applicant presents as the basis for his claim. The matter is of substance, not of form. Secondly, the court will interpret the relevant provisions of the treaty invoked by the applicant in order to determine the scope of the treaty, which also defines the scope of its jurisdiction under the treaty. Thirdly, the court compares the subject matter of the dispute with the scope of its jurisdiction and decides whether the subject matter falls within such a scope. In this process, the court did not satisfy itself that the respondent state's conduct actually violated the treaty, but only need to see if these conducts are capable of constituting such violations. If they do, then the court has subject matter jurisdiction over the dispute. So the increase in the number of unilateral applications and the preliminary objections reflect a tendency to resort to judicial process for dispute settlement in international affairs. There may be different reasons behind these unilateral actions. For instance, first, in some cases, judicial recourse constitute the last resort after a prolonged and tangled negotiation process, which failed to settle the dispute. So one of the parties decided to come to the court. In some other cases, the applicant state come to the court with the hope to achieve quick and effective resolution of the dispute. Yet there also exists the third type of cases brought up by one of the states to a dispute that is for political purposes. The applicant state seeks to exert public pressure on the respondent, or where the institution of proceedings in the ICJ would serve domestic political purposes. Of course, whether the court can or cannot meet the expectations of the parties is an entirely different matter. What is required of the court is to discharge its judicial functions in accordance with international law. Unilateral institutions in recent years have also drawn strong reactions from some of the respondent states. Here I mention a few examples. First, in the first case, the Marshall Islands cases, that the Marshall Islands in 2014, in view of lack of progress in nuclear disarm negotiations, it instituted proceedings in the court against the 9 nuclear weapon states, including United States, Russian Federation, the United Kingdom, France, China, India, Pakistan, Israel, and North Korea. It alleged that these nuclear states had breached their obligations with respect to nuclear disarmament and cessation of the nuclear arms race at an early date. 6 of these states do not accept the compulsory jurisdiction of the court under Article 36, paragraph 2 of the statute. They either did not respond to the application at all or replied that they did not accept the court jurisdiction. Only the UK, India, and Pakistan have accepted the compulsory jurisdiction of the court and took part in the proceedings to raise objections to the jurisdiction of the court. In 2016, these 3 cases were dismissed by the court on the ground that the Marshall Islands had failed to establish the existence of dispute between the parties at the time of the filing of its applications. In the wake of the event, the 3 states, namely the United Kingdom, India, and Pakistan, all amended their declarations of acceptance made under the Article 36, paragraph 2. We call it optional clause declaration, specifically to exclude similar matters from the scope of the court's jurisdiction. The UK, on the 22nd February 2017, it revised its declaration and added 2 reservations to its declaration. First, United Kingdom United Kingdom does not accept the court jurisdiction in a case if it has not been notified of the dispute or claim 6 months in advance. Secondly, the United Kingdom does not recognize the court's jurisdiction over disputes relating to nuclear disarmament or nuclear weapons unless all of the other nuclear weapon states party to the NPT have also consented to the court's jurisdiction and are party to the proceedings. Likewise, India, in March 2017, Pakistan, and in September 2019, India, also amended their declarations respectively, inserting new reservations which in effect would preclude similar subject matters from falling within the jurisdiction of the court. So this is the first case. In the second case, the whaling case that Australia instituted against Japan on its whaling scientific program. In 2015, after the court decided in the case that Japan had breached its international obligations under the 1946 International Convention for the Regulation of Whaling by carrying out its scientific whaling program, JAPA-2, Japan have withdrawn from the Whaling Convention and modified its optional clause declaration specifically to exclude disputes relating to living marine resources from the court jurisdiction. So this is the second case where the respondent state withdraw its acceptance of court jurisdiction in certain area. In the third case, that's in the case between Nicaragua versus Colombia in 2012, 1 week after the court delivered its judgment in the territorial and maritime dispute between Nicaragua and Colombia, Colombia decided to withdraw from the Pact of Bogotá, which was the basis for the court's jurisdiction in that dispute. And more recently, in 2018, after Iran instituted proceedings against the United States on the basis of the 1955 Treaty of Amity, Economic Relations and Consular Relations, we call it the Treaty of Amity between the two countries, the United States terminated that treaty. So all these instances took place in the past 8 years. It shows that the jurisdiction of the court is a significant matter for states. Whether a dispute should be submitted to a third party for a binding settlement, whether a dispute should be subject to judicial scrutiny, and whether a dispute should be examined as a separate legal issue in the overall political context. All these are not purely legal issues or issues that can be determined purely on the basis of a law. They are first and foremost political questions, usually to be decided at the highest level of the political authorities of the state. For the court, it is by no means a procedural matter. Its decision on jurisdiction is just as important as that on merits. So the court's decision on jurisdiction and admissibility is always made in the form of a judgment. So this is the first aspect I want to highlight in this lecture. And you can see from this particular angle, the nature of the cases that the court deals with. Now I tend to discuss some incidental proceedings. I also feel they feature a new trend in the court's work in recent years. The first incidental procedures I would like to discuss with you is the request for the indication of provisional measures of protection. During the course of the proceedings, as you know, either party at any time may request the court to indicate provisional measures of protection under Article 41 of the statute and Article 73 of the rules of the court. If it considers that, if the party considers that ongoing dispute may cause irreparable prejudice to its rights before the judgment is rendered. Such a request enjoys priority over all other cases. Upon receiving the request, the court should hear the parties as soon as possible. Under certain circumstances, if the court considers there could be some irreparable prejudice to the rights of the parties, if provisional measures were not taken, the court would by itself order such measures. Up to the 1990s, the court was quite restrictive in granting such measures. Before 1999, there were 21 requests for the indication of provisional measures, and the court granted provisional measures in 12 cases. From 1999 until the present day, the court has rendered 35 orders on provisional measures. That's to say, out of all 56 provisional measures orders in the court's 75 years history, almost 2/3 were made in the recent 20 years. We notice with these more cases, actually the jurisprudence on the conditions for the indication of provision measures also developed. According to the settled jurisprudence of the court, a request for the indication of provision measures should fulfill 3 conditions. First, there must be a prima facie jurisdiction. Second, there must be a risk of irreparable prejudice to the rights that the request intends to protect. And thirdly, there is an urgency in the circumstances. The early cases in which the court indicated provision measures generally concern an ongoing armed conflict or situation of crisis. For instance, in 1979, Tehran hostage case, the 1984 case concerning military and paramilitary activities in and against Nicaragua, the 1986 frontier dispute between Burkina Faso and Mali, and the 1993 Bosnia genocide case between Bosnia and Herzegovina versus Yugoslavia, and the 1996 case concerning land and maritime boundary between Cameroon and Nigeria. In recent years, provisional measures have also been indicated in cases concerning human rights protection and environmental protection cases. For a long time, the reasoning in the court's provisional measures orders tend to be simple and straightforward. In determining whether to indicate provisional measures, the court mainly evaluated its necessity in terms of the risk for irreparable damage and urgency of the situation. It has shown reluctance to indicate provisional measures in cases where punitive damages or other forms of satisfaction would be the proper remedy if the claim is upheld. This was what happened in the 1976 Agency Continental Shelf case, where the court declined to prescribe provisional measures on the ground that if the applicant's claim were upheld, that claim was one which might be capable of reparation by proper means. So there was no risk of irreparable prejudice to the applicant. The court applied the same principle in the 1991 passage through the Great Belt case between Finland and Denmark. On the first criteria, prima facie jurisdiction, in earlier cases, the court would generally be satisfied as long as the applicant would identify a jurisdictional basis, be it a treaty provision or party's declaration accepting compulsory jurisdiction of the court. In the 1993 Bosnia genocide case, Bosnia-Herzegovina filed a request for provisional measures together with its application, asking the court to indicate a series of measures and particularly to order that Yugoslavia cease all acts which allegedly violated the Genocide Convention. At that time, the former Socialist Federal Republic of Yugoslavia, SFRY, had just dissolved. Not only did Yugoslavia refuse to recognize the statehood of Bosnia-Herzegovina, It also claimed to be the successor state of the former Yugoslavia, which was not accepted by the General Assembly. Consequently, there were serious doubts as to whether Bosnia, Herzegovina, and Yugoslavia were parties to the Genocide Convention and whether the court was open to them, the point I mentioned previously. In this context, the court examined the questions of a prima facie personal jurisdiction for the first time in its provisional measures order. After satisfying itself that both states were parties to the Genocide Convention, the court found that Article 9 of the Convention appeared to afford a basis to found court jurisdiction and indicated provisional measures under the Genocide Convention. In the past 20 years, the court has expanded the prima facie examination in provisional measures order rendered, going into questions of subject matter jurisdiction, territorial jurisdiction, procedural preconditions to the court's jurisdiction, and even consider the issue of standing, that means the right of a state to bring the case. It's to be noted that the court has underscored two elements from prima facie jurisdiction as additional and separate considerations for the indication of provisional measures. First, the first element is there must be a link between the rights concerned and the provisional measures requested. In earlier cases, the court had already held consistently that the power of the court to indicate the provisional measures under Article 41 of the statute has as its object the preservation of the respective rights of the parties pending the decision of the case. Therefore, in indicating provisional measures, the court must be concerned to preserve the rights which may subsequently be adjudged to belong either to the applicant or to the respondent. This is easy to understand. The court only has the power to indicate provisional measures within the scope of its jurisdiction under a treaty. It would not indicate measures that have nothing to do with the subject matter of the treaty concerned. For instance, it would not order measures to prevent genocide under the Torture Convention. So this is not difficult to understand. In the 2008 Georgia versus Russian Federation case, the court made this requirement more explicit by stating that a link must be established between alleged rights which the request for provisional measures seeks to protect and the subject of the proceedings on the merits of the case. 1 year after, in the Belgium versus the Senegal case, in its provisional measure order, the court went one step further, requiring a link between the provisional measures requested and the rights that are the subject of the proceedings as to the merits of the case. This formula has been repeatedly applied by the court in all provisional measures proceedings since then, although with a slightly different wording sometimes. But it has so far never rejected any request for failure to fulfill this requirement. The second additional element is the plausibility test. Namely, the court should only exercise its power to indicate provisional measures if it is satisfied that rights asserted by a party are at least plausible. Unlike the first element, the plausibility test has already experienced some evolution in the short period after it was first applied. At first, in the Belgium and Senegal case, The court made clear that the plausibility test only concerned the question whether the rights asserted by the requesting party has a plausible legal basis under relevant rules of international law. In that case, after finding that the rights claimed by Belgium were grounded in a possible interpretation of the Convention Against Torture, the court concluded that the plausibility test was satisfied. At this stage, the plausibility test equals to a plausibility of a rights test. That's to say, the test would be fulfilled as long as the requesting party would identify a treaty provision or other rules of international law which could be interpreted to support existence of the right it asserts. This standard was applied in several cases, subsequent cases. The bar became higher in 2017 in the Ukraine versus Russian Federation case. Ukraine requested provisions measures under 1999 International Convention for the Suppression of the Financing of Terrorism, as well as Convention Against Racial Discrimination, CIRD. Under the Terrorism Financing Convention, Ukraine identified Article 18 as the basis of its right to Russia's cooperation in preventing the financing of terrorism. It requested provision measures on that basis. If the court were to apply the plausibility test adopted in previous cases, it will only need to interpret Article 18 and determine if the right claimed by Ukraine was grounded in a possible interpretation of that provision. However, after noting that Article 18 should be read together with Article 2 of the Convention on the definition of terrorism financing, the court continued to observe that in the context of a request for the indication of provision measures, a state party to the convention may rely on Article 18 to require another state to cooperate with it in the prevention of certain types of acts, only if it's plausible that such acts constitute offenses under Article 2 of the convention. That means it related to terrorist acts. Consequently, the court deemed it necessary to ascertain whether there are sufficient reasons for considering that the elements of intention or knowledge in terrorism financing, an element of a purpose in the definition of terrorist acts, are present. Noting that Ukraine had not put before the court evidence which affords a sufficient basis to find it plausible that these elements are present, the court concluded that the plausibility test was not satisfied and declined to indicate provisional measures under the Terrorism Financing Convention. So in this case, the court applied the plausibility test in a much broader context. Both the applicant's right claims should be plausibly grounded on the relevant convention. There, the court gave a prima facie examination of the case, including its factual basis and the evidence adduced at that stage. So this is the two elements I wish to highlight for the incidental proceedings for indication of provision measures. Another important element relating to incidental proceedings on provisional measures is that the court has now laid more emphasis on the binding effect of provision measures. The legal effect of the court's order indicating provision measures is an area of growing legal significance for international adjudication. By its nature, such orders should definitely have legal effect. But there was not much jurisprudence on that point in the early years of the court. The court in general seems a bit ambivalent about it. For example, in the military and paramilitary activity case, faced Nicaragua's complaint that the United States had failed to comply with the court's provisional measures order, the court simply emphasized in its 1986 judgment that it's incumbent on each party to take the court's indications seriously into account and not to direct its conduct solely by reference to what it believes to be its rights. This situation changed with the Lagran case in 1999, when human rights concerns were much on the rise. Walter Lagran and Karl Lagran were two brothers of a German nationality who moved with their parents to reside in the United States in their early age. In 1982, the two brothers committed murder during an armed bank robbery and were sentenced to death by the Arizona state courts. During the trial and appeal proceedings, they were not informed by the US competent authorities of their right to consular protection and Article 36 of the Vienna Convention on Consular Relations, even after their German nationality was made known to the authorities. On the 15th January 1999, the Supreme Court of Arizona decided that Karl Lagran was to be executed on the 24th February 1999 and Walter Lagran on the 3rd March 1999. Despite intensive diplomatic efforts by Germany at the highest level of the government, Karl Lagran was executed on the 24th February 1999. At 7:30 p.m., The Hague time, on the 2nd March 1999, less than 28 hours before Walter Lagran's scheduled execution, Germany filed in the court the application instituting proceedings against the United States, accusing it of violating its obligations under the Vienna Convention. The application was accompanied by a request for provisional measures, whereby Germany sought order from the court to ensure that Walter Lagran was not executed pending the final decision of the case. The court treated the request as a matter of greatest urgency. It granted Germany's request on the 3rd March 1999, namely the second day before the scheduled execution in Arizona, and required the US government to transmit the order to the governor of the state of Arizona. Notwithstanding the order, Walter Lagran was executed as scheduled. In the merits phase, Germany claimed that the United States had violated its obligation to comply with the provisional measures order. The United States, while acknowledging that there had been a breach of its obligations under the Vienna Convention on Consular Relations, contended that the court's provisional measures order did not create legal obligations binding upon it. In the judgment, the court interpreted Article 41 of the statute and reached the conclusion that its orders on provisional measures and Article 41 have a binding effect and create legal obligations for the parties before the court. It subsequently found that the United States had violated the court's provisional measures order. So this was the first time that the court made such explicit statement on this point, underscoring the legal significance of provision measures in the judicial settlement of disputes. This binding effect has been consistently reiterated by the court in subsequent cases, starting from the provision measures order in the 2008 Georgia versus Russian Federation case. It has become the usual practice of the court to insert an independent paragraph at the end of every order indicating provision measures, affirming that the court's order on provisional measures and Article 41 have a binding effect, thus create international obligations for any party to whom the provision measures are addressed. So this is the development with the incidental proceedings on provision measures. I could still go on for another 10 minutes regarding other types of incidental proceedings, for instance, third-party intervention, counterclaims, but I noticed that my time has run out. I apologize for being a little bit long than I had thought. Perhaps I should stop here by saying a few words to wind up my lecture. I wish to say, in hindsight, the past 2 decades have been a vibrant and dynamic period in the court's 75 years history, with a larger variety of cases submitted to the court. The court has been trusted with the more responsibilities for peaceful settlement of international disputes. It's developed the jurisprudence on jurisdiction and instant proceedings will facilitate states to make a better use of the judicial process for dispute resolution and further strengthening international adjudication mechanisms. At the same time, we cannot but see that the judicial settlement still faces many challenges. To make the court a truly reliable and trustworthy judicial institution for the settlement of international disputes, the court has done a great deal in the past 75 years, and yet it still needs even stronger support and trust from states. Patricia, I think I should stop here to give the audience, the students, the time to raise some questions. I apologize for being too long.
Judge Xue, thank you so much for this brilliant overview of the work of the court. You're probably right that you could go on for longer because indeed, as you pointed out, the case law in the last 20 years has been very rich, which shows really confidence in the court's work. But at the same time, indeed, the complexities that you pointed out, especially with regard to the jurisdictional questions and also to the incidental proceedings issues are really also a testimony of the difficulties that are raised by some of these cases and the necessity for the court to exercise its jurisdiction in accordance with its mandate. I'm very grateful really for this wonderful presentation that I'm sure our participants enjoyed. If you allow us, we would go over time a little bit so that we can see if some of our participants have some questions, perhaps 1 or 2 questions from our participants, because it's really a unique opportunity to interact with you. So the floor is open. Please let us know if you want to just raise your hand and ask a live question or put it in the chat.
Mm-hmm.
I think they are overwhelmed by your presentation and the richness of the information provided. Let's see if we have
I hope
any...
I didn't sound too technical. It's a little bit, I know, detailed and technical in terms of coursework, but between the lines, I hope students can appreciate the new development.
No, and it was very clear. I think you managed to transmit very complex ideas with in a very clear manner. Well, maybe perhaps, well, Robert, there we are. We have a question from Robert. Go ahead, Robert.
So if I may, you know, obviously this is not exactly the topic that has just been discussed so well, but I wonder if you might share a bit of your personal experience with being on the court and what the informality of working with others on these very important cases might be. Thank you.
That's really a very general question. My experience, I've been on the bench for 10 years. I have to say it's a pleasant experience. And members, I assume you are talking about, you know, these collegial relations between other members of the court. Certainly, as we sometimes we see eye to eye. Sometimes we have very heated debate and very different divergent views. But we never hide our views. We always open and we have a debate, but we do respect each other. So if I can answer in a nutshell, that's mutual respect and open-minded, and also very candid, very candid. And this is something I appreciate very much. You see, when we observe the requirement and the statute, we have to, you know, perform our functions independently, impartially, conscientiously. It's not empty words. It really means how we take our work.
Thank you, Judge.
Thank you so much, Judge Shui. I think it's indeed a unique opportunity to know a little bit more about how the court works, and our participants are curious about that too. So we have a next question, and then maybe we'll stop after that, from Evgenia. Go ahead, Evgenia.
Hello, thank you very much for the wonderful lecture. I had more of commentary and a word of thanks than a question. You said that you were concerned that maybe you were a little bit too technical, but in fact, and I think that I say this on behalf of more people than just myself. I think that the technical knowledge, and especially the knowledge of methodology of how the court approaches issues, is extremely valuable, because there are very few good commentaries on the court's work, which is extensive, and not many of those, not many even of those summarize, for instance, the approach to establishing subject matter jurisdiction, or the very, yes, technical, but it's also very clear approach of how the court decides whether to grant or not to grant provisional measures. So thank you very much for this. Thank you.
Thank you. You're very kind. I do hope people understand the word court is very different from the court you're familiar with at the domestic level. And also you have to understand, even for international courts, ICJ also very different from other courts. And this is a general, the courts with general jurisdiction and that can deal with all kinds of cases between states. I mean, all cases concern international law. Unlike EAT-laws, it deals with primarily cases, I see there is a message there, thank you. Cases relating to law of the sea, and ICC dealing with individual criminal responsibilities. But ICJ, it really deals with all kinds of cases between states. So this is important to know what kind of cases that can be considered by the court. That's the question of jurisdiction. So I really gave quite a number of lectures relating to jurisdiction. I do understand, especially in part Asia, where I'm from, people oftentimes don't understand why something you can deal with, something you cannot, why you reject this case but not the other one. But when you have a case, then people got curious. For instance, we have the temple case between Thailand, Cambodia and Thailand that come from our region. And for you, when you immediately want to measure Ukraine versus Russia case, you can immediately associate it with that case. But generally speaking, I think as a judge from Asia, I think we have to give more general courses to our students to appreciate how the court handle these kind of cases.
Thank you so much. There are indeed just one comment in the chat and one question that, if you allow, would be the very last question.
Don't worry about it. You have my time because I use up your time. Don't worry about it.
No, we're very, very grateful. So when the first comment from Bernadette from Singapore is that this was a very rich and clear discussion and we're still digesting it, which was my suspicion from the beginning. Indeed, it was so informative and also detailed and complex. The other question from Chrissy from Singapore, I think it is a question that is quite relevant and perhaps you could address it, and it relates to the fact that the court has also moved into the virtual world, and the fact that the court has amended its rules of procedure to allow to have hearings by video, virtual hearings. The question is about how has been your experience of virtual hearings so far? Has it changed the way the court deliberates or considers the issues before it? I think this is a very useful question also in light of the current circumstances and the fact that the ICJ has adapted to the new circumstances, which was something that is very impressive. So this would be a last question.
Thank you. Thank you. Don't worry about the time. Actually, as long as you allow me to go on, I would certainly like to answer questions, because this is the more interesting part of the lecture. You're right. I didn't mention this because you are doing a wonderful job to adapt to the current difficult times. Likewise, the court actually responded quite swiftly to the situation, the difficulties caused by COVID-19. We had our first meeting, virtual meeting. We started with our internal meeting online through visual link to test technical possibilities, feasibilities for our work. And then gradually we move to judicial activities. But for the court, we have to have certain guidelines and then mandate rules when it's possible. For instance, when you have hearings, some party, some state object to that, say there's no legal ground for you to hold hearing by visual link. But apparently, we could not afford to further postpone the case because the situation was so uncertain, and we don't know how long this pandemic will last, and we cannot sit there waiting for the pandemic is over. And so after some postponement, we did not cancel those hearings and judicial deliberation. We simply postponed them. And then we quickly pick up the technical facilities and make sure that for our internal meetings, judicial activities, confidentiality, first foremost, was guaranteed. That's possible technically. And then we'll see what to do with the court's work, because it so happened several of our judges got stranded at their home countries or elsewhere outside The Hague. And for those judges, even resident in The Hague, could not see each other because the requirement for social distancing. And even we were at the beginning not used to the idea of go to the court wearing a face mask and how the public would look at us, because it's not whether we personally like it or not, it's concerned the judicial solemnity, you know, the authority, whether that's proper. And so we had our internal guidelines, protocols for how to conduct these meetings. And then we move on quickly. The Rules Committee made necessary amendments to our rules, practice and rules. For instance, we have to give legal ground to permit hearing to be held by visual link. And secondly, we have to mend our rules to allow that judgment can be delivered through visual link, because this concerns authority of judgment. But we make a point that the president was conscious of this. He made a point, even with visual link, we always make sure at least 8 to 9 judges were present in the Great Hall of Justice. Even we were facing an almost empty hall, but we can see all the parties in front of us, councils, you know, delegates in front of us on the screen. And of course, we did encounter once in a while some technical disruption, but it didn't really pose major problem for us. I have to say this Zoom link is better than ours. Maybe because we are on a different system, it's more complicated, because we also have to have interpretation. The court works in 2 languages. Now we also have other judicial functions played through visual link. You know, the members of the court are no longer young, and none of us belong to the digital generation. You know, so it's when you play so many gadgets at the same time, it's not easy fun, you know. But to my happy surprise, we got along quite quickly, and it's something I do realize now. After pandemic, COVID-19 world really will change greatly in this aspect. You could call it a new normal, and it will change the way of our thinking, our perspective, and our way of life, for sure. But so I congratulate you that CIL is really fast, and this is really something I really admire you, and you set up this eAcademy. It's really a good invention. Thank you, Patricia, and Ninova. Your efforts are really commendable.
Thank you so much, Judge Hui, for your very kind words. I think we all share the same goal, is that despite the current conditions, international justice cannot stop, but also training in international law cannot stop either. And that's why we have put together this academy. And of course, it wouldn't be the same if we weren't able to count with such distinguished speakers like yourself, who have, with great generosity, agreed to go long over the hour and share your thoughts, and also replying to the questions of our participants. There was one last comment in the chat also thanking you for your lecture, and also asking if this would be published, but it's public. This is a public lecture. It will be on Facebook, and so others will also benefit very greatly from all your insights. So let me take this opportunity on behalf of Nilofer and myself and of the CIL eAcademy and of all the participants to warmly thank you again for being with us today. These are the wonders of the virtual world, but we give you also a virtual applause because that's what we can do at the moment. This is not a substitute, I have to say. I don't think this is a substitute for in-person meetings and in-person work of the court, but certainly it will, as you pointed out, it will stay with us, and I think there will be more to come in the future in terms of prolonging, not fully substituting, but prolonging work in the virtual world. So thanks again, Judge Shui. I hope you stay well and safe, and that we can meet again soon in Singapore, The Hague, or in Portugal. And again, thank you also to all our participants for attending and your very interesting questions and comments. For the participants, we'll continue tomorrow with another lecture on international dispute settlements with Dr. Ramesh Veramantri. So thanks again, Judge Shu. It was really a pleasure to see you. And thanks for the support to the Academy.
Thank you. Thank you all. Thank you for your very kind words. See you soon, another occasion.
Thank you.
Thank you, Judge Xue. Thank you, participants, for spending your afternoon with us. Just as everyone's been asking, the video of this lecture, as well as past guest lectures, will be available on our Facebook and YouTube channel. To find out more about coming CIL events in the coming year, as well as the last 2 weeks of the eAcademy guest lectures, please follow us on Facebook, Twitter, LinkedIn. I think I've got everything there. Thank you all so much, and goodbye.